Welcome to the first episode of Risk Settlement's podcast, Alternative Litigation Strategies, which features interviews with key industry leaders in the area of commercial litigation and explores ways to mitigate and transfer litigation and settlement risk. I'm your host, Kevin Skrzyowski, the National Director of Business Development at Risk Settlements, and today we'll be discussing trends in advertising, class action, litigation, and settlements. I'm honored to be joined today by Roger Colaizzi, partner in Venable's Washington, D.C. office and chair of Venable's renowned national advertising litigation practice. Good morning, Roger. Thank you for joining.
Hey, good morning, Kevin. Great to be here. Thanks for having me.
Thank you. You know, Roger, obviously the business world and certainly the legal world have been impacted by COVID over the past year. How has your practice changed during that time?
Well, initially everybody thought, what's going to happen with litigation? What's going to happen with everything? And, we're seeing that just the same types of cases that we've had before. Everybody's working from home. We're seeing clients really wanting some assurances on, litigation costs, litigation settlement. We've seen take rates have gone up during COVID. We've seen a lot of social media and a lot of the types of things that you might expect, certainly looking back with a 2020 hindsight, seeing that people are at home spending more time on social media, more time with Facebook pages, seeing the promoters promoting free money, getting people to sign up for claims, and all sorts of the issues that come with that in terms of fraud, waste, and abuse. So it's been interesting. We've seen some trends take place after COVID, and everybody was home in terms of what we're seeing in number of cases and that sort of thing. And I can get into that a little bit later. But generally, it's been initially a concern that we might not be able to have a real litigation practice to it's just booming in the sense of doing depositions remotely, doing trials remotely. And it's just been interesting change in how we all litigate in this world.
Yeah, it certainly has been. And those are all great points. I'd love to drill down into each of them. So let's start with the first item you mentioned, that types of cases. So, each year, of course, we see that spending on certain types of cases, increases or decreases. I read some market studies recently that indicated that some types of consumer cases were on the decline over the past year, but other areas, such example, drug litigation or food and beverage litigation is on the rise. What are the hot advertising litigation topics that you see trending now and for the rest of 2021?
Yeah, so I can confirm that there has been an increase in food and drug litigation, just in my own practice, seeing more food cases, more drug litigation, and also dietary supplements. We still are seeing a steady stream of consumer fraud, false advertising claims, and we're also seeing an increase in brand protection and trademark claims. Although not strictly advertising, it all kind of gels together, and we're seeing more of the trend of protecting assets and also seeing competitor versus competitor in addition to the class actions, which we hadn't seen for a while on the competitor versus competitor cases. They just had been steady, but now they seem to increase as well. So I would say there's a lot of focus on advertising now, whether it's class action or competitor versus competitor, or regulators like the FTC or state AGs going after marketing companies.
Exactly. And you mentioned that the cost is one of the most important criteria now. Of course, with the healthcare crisis, there is a massive slowdown in economic growth. Definitely, understand why the clients' priorities have shifted, and cost control has been their number one focus. What are you able to employ to manage those costs and to employ risk reduction strategies to satisfy the client's cost control demands?
So initially, and one of the things that was clear at the very beginning is there's a very high focus on costs. And I say the very beginning, I'm talking about as mid-March came, and we all were sent home, right? And so from clients, there's an initial focus on costs. And that would include, obviously the cost of defending litigation, class action litigation. And with the uncertainty, particularly at the beginning of COVID, clients needed to get a sense of, we don't know if we're going to continue to make money or not. We don't know what our budget's going to be, how it's going to be affected. How are we going to, pay for this if we get a bad result? And so when you look at settlements, clients, number one, are not interested in a common fund because they view the common fund as not really relevant or not really directly relevant to consumers being compensated. There's almost always is an amount left over for side prey, and most of the clients don't really get it in the sense of why would anybody want to do that, right?
Right.
And then as it relates to a claims made settlement, which obviously makes sense because it's going directly to the extent there's a settlement and claims are being made by consumers who are eligible. Those are the people who would get the money. And of course, there's a big risk for that. And I guess the third way is to have an individual settlement. And of course, and that means you settle early and the individual who is named on the proposed complaint gets a settlement, the plaintiff's lawyer gets fees, and that's gone. Of course, there's a risk to that because there could be another class action lawyer, plaintiff's lawyer bringing a case, and then you're just right back at it, and that can go on and on and on. So you're not getting a release from the class in an individual settlement. So the focus has been, as a result of all those factors, and particularly the unknowns with COVID, is how do we minimize costs? Making a pitch for you guys at risk settlement, that is a factor that is often used. Having the ability to cap costs and to cap exposure with risk settlements it was something that we've used as an option where appropriate for clients who are interested in that.
No, I certainly appreciate that. And I mean, that's what we always advocate is structuring a settlement, structuring a claims made settlement, and coupling that with class action settlement insurance. It's a way that you provide an egalitarian benefit structure to the entire class, but then for the client themselves, they're actually able to mitigate, cap, and transfer that settlement risk. But it's an interesting point you make about advocating for the claims made over the common fund settlement and why. And I read various industry reports that have indicated that the number of common fund settlements, especially common fund settlements with a side prey reversion, significantly decreased this year, and the number of claims made settlements is on the rise. Is that a trend that you see continuing? And in your personal experience, have you found that more members of the plaintiff's bar have become amenable to a claims-made settlement structure?
Well, I think that's correct. I mean, it is correct from my experience, and my own view is that claims-made settlements are the way it should be because of the direct benefit to the consumer. And I will tell you that we've been in situations in class actions where there's been a fight all the way through discovery, and you get to a trial, and the trial starts, and then there's a settlement. Right, because there's some risk on both sides, as becomes clear in the first day or two of a trial. And in those situations, you might have a benefit to the class that may end up being small. In one situation I had, that was the case. But the fees to the plaintiff's lawyer were based on the time and effort that were in the case. And in this particular court that I'm thinking about on this case, this is where the judge required each named plaintiff to be present at all hearings, right? So there was a huge effort on everyone's part. And when you spend the time in discovery and depositions and hearings and class cert and all of those things, a lot of money is spent. And it's fair to the plaintiff's lawyers, it's fair to the consumers, and it really gives some transparency to the system in terms of where the value is. And so if you have an early settlement and there's not a lot of time spent on by the plaintiff's lawyer, then of course there should be less. And one of the reasons that you have these common funds, or that they're pushed to have a common fund, is because of an early settlement where a plaintiff's lawyer might say, well, I'm not going to make much money if I don't have a big common fund from which I can get argue a percentage of fees I should get, the percentage of the fund as fees. And that's just the wrong approach, right? It's not the way the system should work, and it's not the way it was set up. So, I mean, that may answer your question. One of the other things I wanted to mention, and was from one of your earlier questions, and all of this has come to a head in terms of how to keep costs down, what are the take rates like, and those sorts of things that you just mentioned, is just what happened right after COVID started. And looking at just TCPA complaint filings, and that's another area where we've seen a real uptick in class actions. And so with TCPA complaint filings, in March of 2020, March 1 through March 31, which the middle of which I think is when everyone was sent home, there were 250 TCPA complaints filed. The following month, April 1 to 30th, 2020, there were 650 TCPA complaint filings. That's 160% increase just over the previous month. And when you look at 2019 versus 2020, you have a 46% increase for the year 2020. I'm sorry, January 1, 2019 to April 30th, 2019 versus January 1, 2020 to April 30th, 2020. You had a 46% increase just in TCPA complaint filings. So seeing just where immediately after COVID hit, right, and everybody was home, you see a huge increase in filings, and you see, I think you mentioned me the other day about the increase in take rates that you've seen in the work that you guys do in that same period.
Yeah, you're right, and what we found, and this is what I attributed to almost solely, is that with working from home being the new normal, people are spending a lot more time online and engaging with social media and traditional media. And you had mentioned, various reasons why you advocate for claims-made settlement structures over a common fund. The only issue then is that you really never know what the take rate will be. And everybody has their idea based upon their own research and market information as to what the normative ranges may be. But we've seen with everybody working from home that historically take rates have fallen outside of normative ranges about 25% of the time. But we saw, especially like you had mentioned, everybody who started working from home in mid-March, with some cases that we worked on, take rates in excess of 50%. And I don't think anybody anticipated that the rates would increase so drastically. And again, I think that's just because people are at home in front of their computer, and also the work-life balance has been blurred. And so you're on your phone, you're engaging with social media, and it really has been, I think, a change that nobody anticipated would be so drastic.
Yeah, it's amazing. And I don't know the rest of the world in terms of working from home, but what I've struggled with is there seems to be no difference between a work day and non-working, right? This is harder to manage when you're working from home, and it's, you're not leaving your computer at the office. You're not leaving the office, right? And you're at home, and so you're always on. So you're working, you're looking at your personal stuff, you're looking at your computer. And I often find myself spending 12, 14 hours a day sitting at my desk doing both, right? Because it's you don't have the commute, you don't have the time period where you're decompressing or anticipating going in the morning, what you need to do, or decompressing at the end. It's just kind of a constant, and that might explain, why we see much more activity in this area, just in terms of take rates, as well as the plaintiff's part saying there's a lot more opportunity here than we thought might happen.
Yeah, but we haven't just seen an increase in take rates. We've also seen an increase in the amount of fraudulent claims that are filed. Now, I know, a large part of what you specialize in is advertising law, but you practice in multiple different areas. But since most of the advertising cases that you settle, I would imagine, are publication notice campaigns, I mean, what are some of the methods that you employ to minimize waste, fraud, and abuse in the claims process, or these claims that come in through some of the feeder websites like Top Class Action? I mean, how do you prevent just people who are sitting at home getting the email alerts that they can go grab free money to weed them out of the claims process?
Yeah, so that's a great question. And I have to say, I don't know that you can completely prevent it. It's out there. And for all of those sites that are promoting, class action settlements, while it's beneficial to consumers who would have the opportunity to make a legitimate claim, it also increases the fraud, right, and the waste, right, and the cost, because you don't have, these are people who never purchased a product or service. And so when you look at that, how do you try to minimize it and reduce it? I would say first is a good claims process, right? The claim form, how it's set up and limited, and either if you're lucky and you do direct sales, you would have a list of people who purchased the product if you're only selling through the internet. Retail's a different story because you don't have that line, but you can't say who purchased it at retail, but you can limit the mailing address and IP address in the claim form, right?
Right.
And it's possible to require, in the claim form, additional detail about the purchase beyond just, I made a purchase, right? A claim of a purchase. Even if it's simply an affidavit, so to speak, right? Or swearing under oath type of thing, where you might have a jurat that, the claim is truthful. Some people, their conscience gets to them if they're really not making a claim and they abandon. Second, having a great claims administrator is key. Someone who's going to monitor and advise or alert you when, where claims are coming from, and tracking some of these promoter sites and seeing, different upticks there or where, a lot of the claims are coming from, and so that we could investigate and say, well, why are so many coming from this particular place, right? And then also good auditing procedures, looking at demographics, looking at similarity in names, looking at identical IP addresses, that sort of thing. All of that, is often put on the shoulders of the claims administrator, and the good ones will do that and offer that, and certainly will alert you when you see that. Those are things that top of my mind that come in when I'm thinking about how do we avoid this. And I would say that the number one thing, it really comes from a good settlement and a good administration, a good claim form, and the time really has to be spent there in making sure that you can limit the fraud and abuse when it comes to the notice and claim forms.
Yeah, I think those are all very interesting, great ideas and great methods to employ to minimize waste, fraud, and abuse. In fact, I know we advocate a lot of the similar methods when we're consulting with businesses and their counsel. So no, Roger, we're running out of time a little bit, and I know I wanted to get to one more thing. I know that each year Venable hosts a large advertising law symposium, but it's my understanding that because of COVID, that might take a different form this year. So what type of programming can we look forward to from Venable for the rest of the year?
Yeah, so we have done our advertising law symposium for 8 or 9 years now, and it was a huge success. And we typically do it in April. So, of course, last year we had to cancel it, and this year as well we weren't able to do it live. What we have done is is what we've called not a symposium, but a virtual ad law CLE bonanza.
Okay.
And it's actually going on. Yeah, it's in April this year. It was April 13th through 15th, and actually this week, but I think by the time this gets out there, our podcast here, it'll be mostly over. But the good news is that it will be posted on our website, and you will be able to see it if you want to go there. That's at Venable.com /AdLaw. And you also see there things like our All About Advertising Law blog, which is worth signing up to. It's the latest in advertising and what's going on virtually day to day as developments come in. We also just republished our Advertising Law Toolkit, which helps stay on top of other industry developments. And all of that, again, is at Venable.com. Maybe it's /AdLaw. If you go there and just search AdLaw at the Venable.com, you'll get all of those things. We're also doing webinars throughout the summer. There's one on latest developments in class action litigation, in terms of advertising class action litigation. And that's going to be sometime this summer. And then by fall, we're hoping to go live again with our webinars, and hope that all your listeners are interested and would like to attend. And we almost always get, for the lawyers out there, get CLE credits for most of the advertising webinars that we do, so that people get an extra benefit.
It sounds like you have a lot.
Thanks for letting me give a plug there. Yeah.
No, definitely. It sounds like you have a lot of great programming going on now and in the future. It's great. Well, I think that's all the time that we have for today. Roger, it was a pleasure having you as my guest. Thank you for your time and your valuable insights that you shared with our audience today. I certainly do appreciate it.
Well, thank you, Kevin, and thanks to Risk Settlements. You guys have been great, and it really is a product and service that we use as appropriate, and it is something that I would say almost all my clients ask about. And so I'm glad you guys are out there and offer that product and service.
That's very much appreciated. And I would also like to thank our audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you would like a transcript or summary of today's recording, or if you have concerns over the financial volatility caused by pending litigation, and would like to learn more about litigation and settlement risk transfer solutions that are available to you, please visit the Risk Settlements website at www.risksettlements.com, or you can reach out to me directly at kevins@risksettlements.com. Thank you for listening, and we'll see you next time.